downward trend, a downward trend in state investment in public education, which of course affects the quality of education, the resources available for education, including teachers, in recruiting enough teachers, so practically training the teachers and paying them a living wage and ensuring they have all of the resources required. And on the other hand, we have the state also shrinking back in regulation, right? So this narrative or approach that the market, because now private sector is coming in to fill the gap that the state is leaving, that private sector can come in and provide that education, but also the market must be left to regulate itself. So the state should reduce the interference and involvement in private sector matters. So leaving the space for private sector to provide education and be involved in education in other ways. And this, of course, had very detrimental impact on the right to education because it resulted in increasing inequality, where now more education expenditure is being passed on to households, which of course means there will be a distinction in who is able to access education, the quality of education that they're able to access. And these impacts also compounding according to, more girls now being excluded from schools, of course, people living in poverty being excluded from education, and learners with disabilities also being excluded from education because there's a limit to how much private sector will be able to invest in and how far it will reach, right? Which is why the active participation of the state in the provision, in the financing, and in the regulation of the education sector is so critical. And all of this is a part of a broader effort to, create a market, commercialize and commodify. And it's something that also resonates across other public services. So the Abidjan Principles were an effort to clarify what human rights law actually provides around the state's obligations regarding education. What are the state's obligations regarding the provision of education, particular public provision of education? What are the state's obligations around regulating private involvement in education? And you'll see that the full name of the Abidjan Principles is very deliberate and intentional about bringing this to the fore. They are the guiding principles on human rights obligations of states to provide public education and to regulate private involvement in education. So it's bringing it together, it's clarifying what the obligations are, and in a sense, being a tool to equip states themselves to understand how they should be implementing or ensuring that the right to education is being realized, for education advocates who want to, bring in the element of accountability. What can they hold on to within the law? Well, how can they articulate the arguments that they want to make? Even for communities, because the principles have been used also within communities to just unpack and clarify what this right to education means. Beyond it being a piece of paper or a line in a piece of paper, how should that translate into their daily lives? And that's a little bit of a snapshot on how the Abidjan Principles came to be and the background on that. And with that, I will segue to the next speaker who will tell us a little bit about the commentary to the Abidjan Principles, why a commentary and what role it's supposed to play. And I'm very pleased to introduce Megan Cappell, who is the Deputy Director of the Oxford Human Rights Hub, to tell us about the commentary.
Yeah, good morning, everyone, from a rainy, dreary day in the UK, but it is much warmer and much more lovely to be on this webinar to talk about the 6th anniversary of the Abidjan Principles. So as Ashina mentioned, I'm Megan Campbell. I'm the Deputy Director of the Oxford Human Rights Hub. And over the past year and a bit, we've been publishing commentaries on the Abidjan Principles. And to date, we've published 7. So I'll just run through the list of the 7 as a way to set up for the conversation we're about to have. First, we have Ashina Mitsumi, who gave a wonderful introduction to the commentary. Then we have Anne Skelton and Prakimi Mutu, who gives a wonderful interpretation of the scope, application, and interpretation of the guiding principles. We have Sandra Fredman, who gave a very insightful commentary on the equality and non-discrimination education and how the principles reflect those values. Then we have Jacqueline Mowbray, who gives a excellent commentary on how these principles reflect and strengthen the right to public education. Maria Ron Balsara, who just recently published with her commentary, giving the, I would say, very timely in relation to the news that came out in the UK today about increasing cost of living, about the resourcing and financing of public education, governance and non-retrogression. Then Roman Zingard gives a multifaceted commentary on liberty to choose, and establishing educational institutions, the obligation to respect, protect, and fulfill the right to education in the context of private involvement. And the commentary rounds out again with a wonderful commentary by Anne Skelton and Brakumi Mutu on the implementation of the guiding principles. So in combination, these 7 pieces give a really rich treasure, a rich archive, a rich resource on what these principles mean and expand upon and deepen our understanding of the text of the principles. And they are a wonderful resource for everyone working in this space because they really do give that depth to what these principles are about and how they can be operationalized in the delivery of education. And just to conclude with why was the Oxford Human Rights Hub involved in this? Well, our director was Sandra Fredman, and she was involved in the process of drafting and was involved in the commentary. But more importantly, it reflects the hub's values, and I think values that we all share, that children's right to education, the quality of education, their access to education shouldn't be contingent on the character or nature of the provider of education, but it transcends that. So whoever is involved in providing education, public or private, children should be receiving the best, highest quality of education. And what is so exciting about the principles is that it pierces through these public-private divides. And what the commentary is, it kind of echoes that in that it is freely available. So we wanted to make sure in working with our partners on this, that this resource was not behind any firewall or any paywall, that you could get on the internet and you could download these for free so that the knowledge exchange about how to enhance education for children was freely available to all. This was probably one of the most exciting projects I've been involved in that it really does transcend those academic silos to ensure that this knowledge on education is freely available. So at that, I will turn it over back to Aya, or Sheena, pardon me, so that we can have a more substantive discussion about the commentary.
Thank you so much for that, Megan, and to the Oxford Human Rights Hub for being willing to make this important resource widely available to more and more people so that it can be useful and transformative. So with that, let's move forward with the presentations. We have an insightful lineup of experts who have very kindly and generously agreed to share their wisdom and insights with us, including what went into the drafting of the sections that they put together, the reasoning, and how we can use it and how it's relevant in today's context. First up, we'll hear from Dr. Perekeme Mutu, who is the research assistant within the Faculty of Law at the University of Pretoria, who will discuss the scope, application, and interpretation of the Abidjan Principles, covering Guiding Principles 1 and 4 to 7, as well as their implementation, which covers Guiding Principles 91 to 97. Over to you.
Yeah, thank you so much, Ashna. Right. Can you hear me?
Yes.
Okay. Thank you so much for having me. And I want to also appreciate the organizers of this program and the opportunity to present our commentary. It's a commentary I co-authored with Professor Anne Skelton. Unfortunately, because of other engagement, she couldn't make it. So I'm going to be presenting the commentaries on behalf of myself and on behalf of Anne Skelton. So I don't know if we can share my screen because I have, let me see.
Yes, you should be able to share your screen.
Okay, let me see.
There should be an arrow at the bottom of your screen, a green arrow.
A green arrow, okay, let me see. Sorry about that. It said at the bottom of the screen, saying that.
Yeah, you should see a green arrow saying share, a green arrow going upwards.
Let me see. The only arrow I see here is note. No. Slide sorter, no. Slideshow, I don't think it's this. Fit current.
Alternatively,
yes.
Alternatively, if you email us your presentation,
Okay,
we'll
great.
share it for you and you can proceed.
Okay. Let me do that. Let me email it to you quickly. Sorry about that. Okay, but are you here? You are hearing my voice, right?
Yes,
Hello?
and we can
Yes,
see you.
please. We can
Okay,
see.
you can see me. Hello?
Yes, we can
Yes.
see you. We can hear you well. You can
All right. Okay.
go ahead with
In that case, let me proceed. Then you and I'm not seeing you, but let me proceed. So my presentation, like highlighted, is going to be focused on the article or the commentaries I co-author with Professor Anne. And the first commentary is going to be based on Principle 1, 4 to 7, which deals with the scope and also the application and interpretation of the Abidjan Principle. For the purpose of analysis, we divided the first the scope into two sections. In the first section, we look at what in terms of the first section, we look at the human rights instrument involved, what human rights instrument the Abidjan Principle cover, because it has already stated that the Abidjan Principle does not seek to establish new laws. Rather, it seeks to reaffirm, consolidate, and interpret existing laws. So in that regard, what are we talking about? What kind of laws are we talking about? So in terms of the scope, we adopted a broader interpretative approach where we look at not just hard law, we want to talk about hard law in terms of binding treaty provisions, but also look at soft law in the form of general comments, concluding observations, and commentaries commentaries and principles that have been established and gain international recognition by non-state actors. So that was when we talk about the laws we cover. So we look at both soft laws and hard laws. Then in terms of the education, then the second aspect of the scope, we look at what level of education are we talking about, does the Abidjan Principle cover? So in this case, we look at pre-primary education, we look at primary education, secondary education, we look at technical and vocational education and training, adult education, and formal and non-formal education. So in terms of the scope, that is the area we covered. Then in terms of when we talk about the hard laws, which informs the legal foundation for this principle, we look at Article 21.6 of the Universal Declaration of Human Rights, though the Universal Declaration of Human Rights is not a binding treaty, but because of the universal recognition, again, there is no interpretation or research you carry out in terms of international human rights that you not make a reference to the Universal Declaration of Human Rights. So we'll look at Article 26, one of the Universal Declaration of Human Rights, and it provides that everyone has the right to education. It recognizes education as a fundamental human right and places the obligation on the state to make education free, compulsory, at least at the elementary and the fundamental stage. It also requires state to make technical and professional education generally available and higher education to be made equally accessible to all based on merit. And this provision is also reaffirmed in Article 13 and 14 of the International Covenant on Economic, Social, and Cultural Rights. Also, it's also reaffirmed in Article 28 and 29 of the Convention on the Right of the Child. So I'm not going to go into detail on, because of time, into the provision of this thing. But the area I'm going to dwell a little bit on is the issue of pre-primary education, because the pre-primary education, we covered it in our article, is not expressly provided for in international legal instrument. But after the adoption of most of these international instruments, the issue of early child education has gained a prominence, and this is evident in the adoption, in its inclusion in, or the adoption of the Sustainable Development Goal 412, which commits states to ensure that all children have access to quality early child development, care, and pre-primary education. Also, a study conducted by Friedman and others of the concluding observation of treaty bodies observed that these treaty bodies actually interpreted the right to education as including pre-primary education. So in terms of the scope, even though pre-primary education is not recognized explicitly in these binding treaty bodies, based on interpretation of treaty bodies, which also form a soft law, they interpreted pre-primary education as forming a part the right to education. So as a result of that, our scope also covered that. Then going into also the international law also recognized the establishment of private education. So we look at the liberty of parents and guardians, individual and private entities, to establish and direct educational institutions, which is provided in several international organizations. Article 29 of the CRC provided for, and that is also replicated in Article 22 of the UNESCO Convention and Article 13 and 4 of the International Covenant on Social and Cultural Rights. So all these institutions actually provided a law guarantees the establishment of private education. However, such liberty is subject to compliance with minimum standard by state to which all private education institutions must comply. So in other words, state must establish standard in which these educational institutions must comply with. However, it remains the state obligation to guarantee, monitor the realization of the right to education where private actors are involved in the provision of education. Then that is for principle 1, which deals with scope and interpretation and application. Then principle 4, application and interpretation, the legal foundation. In this regard, we look at general comment number 13. Just to read them, start with what the principle entails. It provides that the guiding principle are intended to apply and interpreted in context of state obligation to respect, protect, and fulfill all human rights, including civil and cultural, economic, political, and social rights, both within the territory and extraterritoriality. So in terms of general legal foundation or the legal justification for this principle, we relied on general comment number 13, which affirms that international law imposes these 3 forms of obligation to respect, to protect, and fulfill on the state. In terms of obligation to respond, state must not take actions that undermine access to free, quality public education, e.g. unregulated private education. In terms of obligation to protect, state must prevent third parties, including private actors, from infringing on the right to education, ensuring education is not commercialized in ways that exclude or discriminate against marginalized groups. In terms of the obligation to fulfill, state must take positive steps to progressively realize the right to free quality education for all, including towards adequate funding and regulatory measures. The obligation is not limited to state geographical territory, but also extend to the extraterritoriality. In this, we relied on the Maastricht principle on extraterritorial obligation of state in the area of economic, social, and cultural rights. Just to explain this further, at least we're all aware of what is going on internationally since President Donald Trump came into power, and one of his statements as a way of resolving the Gaza crisis is to take over the Gaza crisis. So I'm just using it as the Gaza territory. So I'm just using this as an example. So if for whatever reason they actually succeeded in taking over this, so if we have children in school, so the government is responsible for ensuring that children have access to quality education and regulate whatever educational policies that is taking place in Gaza. So assuming that happens, so in terms of extraterritorial principle, that such a policy will not only be limited in the US, but US also have obligation to ensure that children schooling in Gaza are not affected. So this principle are adopted. The Maastricht principle are adopted to fill the protection gap created by the fact that standard approach of human rights obligation being limited to state geographical territory provide insufficient right protection. So this is just to ensure that look, the conventional protection mechanism is not sufficient when issues happen outside the territory of states that have obligation, to protect those extraterritorial jurisdictions. So these principles are put in place to ensure that they are regulated. Then in terms of principle 5, complemented by other human rights obligations. So again, reading the what the principle entails, principle 5 entails that the fulfillment of state obligation with respect to the right to education must complemented by other human rights obligations, as well as applicable international legal obligations, including international human rights law, international refugee law, and international criminal law. The guiding principle affirms the indivisibility and independence of all human rights. It reflects the view that realization of the right to education must be achieved within the broader context of realization of other human rights. It depends on states to eradicate all barriers that impede enjoyment and realization of the right to education. A general example of this in terms of the interdependence of is the link between child labor and child right to education. Article 1 of the International Labour Organization Minimum Age Convention obliges states to ensure that effective abolition of child labor that will interfere with the compulsory education or for which they are too young. Also, Article 22 of the Convention relating to status of refugee urge states particularly to accord refugee access to elementary school. CRC committee also raised concern in 2029 about the high number of out-of-school children in Syria as a result of the conflict. The committee advised the state to ensure that children affected by the conflict have access to education. So in terms of Principle 5, these are the legal instruments we relied on to ensure that basically it reaffirms that education, human rights are indivisible, and achieving the right to education also rely on ensuring that state addresses other challenges that could directly or indirectly affect the enjoyment of the right to education. Then Principle 6 and 7 are interrelated, so we actually discuss them together. And the principles state that this guiding principle should not be interpreted or applied in a manner which will serve to limit, restrict, or otherwise undermine the right recognized under international human rights law and standards, or any domestic law that are consistent with international human rights law. Guiding principles 7 and 6, like I said, are interrelated, so we discuss them together. And this instrument, and in terms of the legal foundation, we rely on Article 5 of the International Covenant on Economic, Social, and Cultural Rights, Article 41 of the CRC, and Principle 41 of the Maastricht Principle. And so that is basically the legal justification for the principles and what entails. So the next section, I'm going to discuss their continued relevance. In terms of their continued relevance, I look at addressing contemporary challenges. In the face of increasing education privatization, digital learning inequalities, and socioeconomic disparity, this principle provides ongoing guidance for states to regulate private involvement and ensure inclusive, equitable, and quality public education. It also ensures legal guidance and policy reform. These principles will continue to influence legal framework, constitutional interpretation, and policy reform globally, reinforcing the judiciability of the right to education and provide guidance to court, policymakers, and human rights advocates. An example of this situation was the case we had in Uganda, where the court has to intervene. It has to do with the model of funding that the state adopted, which perpetuates inequality in the education system, and a civil society organization known as the Initiative for Economic, Social, and Cultural Rights challenged the funding model, and the court had to intervene and actually referred the state to seek guidance from the Abidjan Principles in terms of their implementation and in terms of introducing or implementation of policy regarding education. So this is a typical example of how the Abidjan Principle can provide guidance in terms of reforms. Okay, in terms of relevance, it also enhances accountability in education governance. The principle provides states with a clear accountability framework, ensuring that education policy are implemented in ways that uphold human rights and prevent discrimination and exploitation and exclusion. And it also addresses challenges of privatization and commercialization. Countries are still witnessing the rapid expansion of private education, often at the expense of quality and accessibility. This principle guides government in effectively regulating private actors and ensuring that they do not undermine inclusive education quality. So this is the end of the first this thing. I'm going to rush through the second commentary, which is 91 to 97. Principle 91, the implementation. It provides that including the legislative, judicial, and executive branches should effectively implement means, including where necessary, by adopting where necessary, appropriate means, including by adopting and enforcing the required legal and budgetary reforms. States should apply this guiding principle when designing and implementing domestic, regional, and global education, and developing plans, laws, and policies, and dedicate the necessary human, technical, and financial resources for their implementation. The realization of the right to education is a task that engages. What this principle tries to bring forward is the fact that the realization of the right to education engages all arms of government, both the executive, legislature, and the judiciary. This means that states have to implement legislative, administrative, and budgetary, judicial, and other measures that conform to international treaties, including the Abidjan Principles, to ensure that right to education is respected, protected, and promoted through regulation of private actors in education. In this article, mostly in terms of sources, we mostly relied on in terms of published papers. Then guiding principle 92, formal accountability mechanism and litigation. The principle provides that states should monitor and put in place effective accountability mechanisms for implementation of this guiding principle as part of their effort to respect, protect, and fulfill their right to education. In terms of legal foundation, we relied on general comment number 1 of the Covenant on Economic, Social, and Cultural Rights, which obligates states to establish and maintain transparency, a transparent and effective system of monitoring education. We also relied on the Abidjan Declaration, which states commit themselves to develop comprehensive national monitoring and evaluation system in order to ensure accountability. Under the Abidjan framework, states have primary responsibility for monitoring and building effective monitoring and accountability mechanism. Then we also rely on the CRC committee general comment number 1, and also the UN Human Rights Council resolution on the right to education, which was adopted. Then we go to general, apology because of time, I'm just running it through. Then guiding principle number 3,
sorry to interrupt you, Dr.
Yes.
Mutu. Just a reminder that you now have 2 minutes.
Yes, I know. I'm timing myself. That is why I'm running. So in terms of public institutions, so in terms of principle 93, increasing public awareness and institutions, we look at, in terms of legal foundation, we look at the Human Rights Council resolution, which advocate for research and awareness raising activities to ensure increased understanding of broad impact of commercialization of the education and enjoyment of the right to education. Then in terms of guiding principle number 4, it emphasizes the role of international human rights institutions and other actors. In this regard, we rely on the general comment number 10 of the Committee on Economic, Social, and Cultural Rights, which highlight the role of national human rights institutions and recommend one of the appropriate measures that can be taken as required by international law is collaboration with national human rights institutions, and also rely on the Paris Principles, which mandates states to give national human rights broad mandate to promote and protect human rights. So the Principle 95 deals with ensuring compliance. So let me just run, because for time, let me just go through their continuous relevance. So their continuous relevance, it provides legal and budgetary reform for progressive realization. Many states still struggle with the issue of the legal framework that adequately protect and fulfill the right to education. These principles remain relevant as it's called for legal and budgetary reform, compelling states prioritize public education, financing, and I think my time is up. Financing, then resource mobilization and commitments, need for continued effective monitoring, accountability, and safeguarding against violation. It's also relevant in terms of sustained awareness and compliance, and then also in terms of capacity building for effective implementation. So if I for the sake of time, I think I will stop here. I'm going to share the slide with whoever is interested. Thank you.
Thank you so much for laying that firm foundation on the aspects of the principles, especially looking at their scope, their foundation, and on the implementation and application, which is critical. We will now turn to the right to public education, which is the backbone of these principles, and it aims to define the obligations of states to guarantee the right to education for all. And so to take us through this, I'm pleased to introduce Professor Jacqueline Mowbray, Associate Professor at the University of Sydney Law School, who will discuss Guiding Principles 29 to 33, highlighting the principles, their importance, and the relevance in today's context. Over to you.
Thank you so much, Ashina. And it's wonderful to hear that described as the backbone of the principles, because that's how I see it too. Apologies for my sort of ghostly appearance. You can see we've had some water damage in this room and we don't actually, the light's not working. So I've sort of got this spotlight over on the side. So I apologize. So as Ashina's foreshadowed, the guiding principles I'm going to talk about, 29 to 33, are focused around the right to public education. So these reiterate a lot of the general principles that were laid out earlier that Dr. Perekame talked about, and also around the right to equality and non-discrimination. So the earlier part of the principles establish those in relation to education generally. What principles 29 and 33 do is apply those particularly in the context of public education. And the real key, or the backbone, to use Ashina's words here, is the first line of Guiding Principle 29, which is that states must respect, protect, and fulfill the right to free, quality public education. So as you'll all realise, this is the first time we get a really clear statement in international human rights law that there does exist a right to public education. And I have to be honest, when I was first approached to be part of the drafting of the Abidjan Principles and to look at this issue about whether there was a right to public education, my initial reaction, and the reaction of a lot of colleagues who I discussed it with, was no, there's not a right to public education. Article 13 of the International Covenant on Economic, Social and Cultural Rights is quite detailed, pretty much the most detailed provision in that covenant, and it doesn't specifically refer to private education. It specifically protects, to public education, it specifically protects the possibility of private education, and the Committee on Economic, Social and Cultural Rights has always said, we don't require a particular political system, a particular way of organising affairs. So there seemed to be an implicit view out there that perhaps hadn't been interrogated that closely, that if states wanted to perform their obligations under Article 13 through private providers, then that was okay. And that was sort of my view as well. But the more I looked into this, the more I became thoroughly persuaded that that was not and could not be the legal position. So what I'd like to do tonight, very conscious of time, is try and walk you through some of the steps in the reasoning that got me from no, there is no right, to yes, there is a right. And I suppose the starting point, the initial question I asked myself was, is there any obligation on states to provide public education? So basically taking the most extreme case, would it be possible for a state to comply with Article 13 simply by allowing private education and providing no public education? And when I put the question like that and had a close look at the provisions, it seemed that that wouldn't be possible. So first of all, just generally looking at Article 13 and going oddly to the provisions on private education, they give the liberty for parents to choose schools other than those established by the public authorities. So that suggests that there was generally accepted at the time of the drafting that there would be schools established by public authorities. Otherwise, this liberty would not be meaningful, it wouldn't be a liberty, it would be a necessity. There would have to be private schools in order for education to take place. And we see similar wording in, for example, the Convention Against Discrimination in Education, freedom to establish schools other than those provided by public authorities. That is supported by looking at the travaux préparatoires of the covenant, in which it's just absolutely assumed by all states that there'll be a public system and that will be really the backbone of state. Also, if we look at Article 13.2e, to get technical, of the Covenant on Economic, Social and Cultural Rights, it says that the development of a system of schools at all levels shall be actively pursued. Now, this is an even stronger suggestion of the need for public education, because the private education that is set out in, for example, Article 13.4 is inevitably ad hoc, because it's in response to the liberty of parents to choose their schools. Private schools can be established, but in order to maintain that development of a system, that overall control, that suggests the need of state involvement. And that's been made clear and supported in a number of comments of the Committee on Economic, Social and Cultural Rights, And in practical terms, organisations like UNICEF working in the area have said really only the state can pull together all the components of education into a coherent but flexible education. So that suggests that states probably need some sort of public education. Certainly that was in the mind of the drafters. But if we look more carefully at what Article 13 requires of education, it's obvious that some of that has to be public. So, for example, Article 13 requires that education, primary education particularly, needs to be free of charge. In relation to private schools, Article 13.4 essentially prevents the state from interfering in the operation of private schools. So that would prevent the state from requiring private schools to offer education free of charge. And given that, it's virtually impossible for the state to meet its obligations to provide free education unless it's providing public education, that it can be sure and it has control over the charging of fees or the non-charging of fees. Similarly, rights to equality and non-discrimination and the state's obligations there would also, I think, require public education in that schools under private schools can be legitimately under international law established for particular minority groups or for particular sexes, for example. So while private education may be able to operate on that ad hoc basis, actually public education needs to ensure that the needs of everyone is met, and therefore I think that requires states to establish public education. And that's reflected in a number of comments of the UN Human Rights Treaty bodies and of international bodies. So that's the first step in the argument that states do have to provide some public education. The next question is, do they need to provide that education to everyone, such that we could say there is a right to public education? Or is it enough if they provide some around the edges to mop up what private providers are not offering? And I think the key move here is to say that equality and non-discrimination is a key aspect of the right to education. There in Article 2 of the Covenant on Economic, Social and Cultural. Given there are significant distinctions between public and private education in a number of respects, the right to equality and non-discrimination, I think, requires universal provision of public education and universal access to public education. It's not enough for states just to provide some public education around the edges, because that engages the right to equality and non-discrimination, that not everybody can access that education. So from there, we find effectively that there is a right to public education. And the reasoning is a lot more better supported, and there are more steps in the reasoning, but that's essentially, as reflected in the commentary, how the conclusion was arrived at, that there was a right to public education in international law. There's Sheena on the screen, so I know I've got my 2 minutes to go. So what these principles do, that first principle really does do a lot of the heavy lifting. It establishes that right to public education, that has to be free and that has to be quality. And as we've discussed tonight, that's a really important point as well. Just briefly to touch on the other principles in that section as well. Guiding Principle 30 builds on that idea of quality in that it talks about standards in public education. And this is a key issue. So the battleground, as Sheena set out in her introduction, around privatisation, there's a really an important first step there of calling the state back in there and making public education available. But the next step is it has to be quality public education, and we have to continuously raise standards. And that's what our Guiding Principle 30 says, drawing on legal authority. Guiding Principle 31 talks about ensuring public education is inclusive. So that's a really important principle. And what I love about Guiding Principle 31 is that it brings in the exact wording used in that case law that we all rely on and the general comment that we all rely on, but it's all in these different places. And Guiding Principle 31 puts them all there together. Guiding Principle 32 talks about governance effectively and the need for accountability, participation and transparency, which is a key issue, principle running through international law, and this is applying it here, and that reflects some of the case law here, particularly in relation to public education. One of the key factors in public education should be some sort of democratic principle in organising it. And then Guiding Principle 33 talks about states in taking measures to address determinants of access to education. So really going into more detail about what are those indirect factors that might affect access to education, water and sanitation, distance from school, access to food, all those background factors. And so again, it's really great that Guiding Principle 33 has distilled all those findings from various findings of the treaty bodies and put them in one principle. So it's all there, and now we can use it, and we are using it. Thanks, Ashina.
Thank you, Jackie. I think we've lost Ashina, if I'm not, or are you back?
Sorry, I'm
Great.
back now. My internet just went out for a moment. I don't know if you can hear me now. Okay,
Yes.
I hope you can. Excellent. Thank you so much, Jackie, for walking us through the reasoning and being so open about the thought process and guiding us through it, even to the conclusion where there is a right to public education. With that, we're now going to turn to Dr. Maria Ronbalsera, who is the Executive Director at the Center for Economic and Social Rights, who will present on a critical element, which is how do we ensure that these systems are properly funded, that public education is properly funded. And in fact, there's already a question in the Q&A from Samuel Safa, who is reflecting on this exact question. So Maria is going to walk us through the underpinning for the financing of public education, which is covered under Guiding Principles 15, 16, 34 to 37, 39 to 41, and 42 to 45. Over to you, Maria.
Thank you very much, Ashina, and all the team of GI, especially Juana, waking up so early. So it is a pleasure and an honor to be here. And it has been a journey, certainly, since the Abidjan Principles were adopted. But even before that, I was just looking at when we started working with them as a draft. And in 2019, we published a study where we used what they were then, the draft principles, to analyze the situation in Ghana, Kenya, and Uganda. And there was a similar study done by the Institute of Education for the University College in London by Elaine Unterhalter and her colleagues. And the study was done, we were doing it in partnership. And that was in Nigeria, Tanzania, Mozambique, and Malawi. And I will be sharing the links very shortly. But just to say much of what Jackie has said, it wasn't without controversy, right? We were just drafting these principles. And as the previous speakers have said, these are very much grounded on legal law. And the whole process to get to the actual principles adopted took a really long time, multiple consultations with academics, practitioners, and everyone. And it was they were also attacked, right, by those people who really wanted to see more private education, who, as Jackie was saying, they were really questioning and undermining this right to public education. So I'm just going to talk, the reason why my paper is only just being published, even when I've been working on this for, as I said, even before 2019, has to do with the multiple guiding principles that the paper is actually explaining the origin and the analysis. No, as Sheena mentioned, these are 15, 16, 34, 35, 36, 37, 39, 40, 41, 42, 43, 44, and 45. So it has had multiple iterations. That at one point it was over 60 pages, but you will be happy to know that now it's much shorter, much to the point. And it just talks about how the states have this fundamental obligation to respect, protect, and fulfill the right to education. And recognizing that the varying levels of quality of resources available to different states, so the heterogeneities, right, and the different contexts, that human rights law allows for this flexibility, incorporating the principle of progressive realization for certain aspects of this right, such as free secondary or tertiary education. However, this principle does not apply to the core obligation of non-discrimination or equitable access as well, which remains immediate and non-negotiable. And progressive realization cannot be an excuse for inaction. States must actively take steps toward fully realizing the right to education by using the maximum available resources. So this is a concept that I explain over and over, right, in my paper, because this refers not only to economic, but also to legal, administrative, technical, and educational. These resources extend beyond those currently at the government's disposal to include those that can be potentially mobilized through both domestic means and international cooperation, right? And that's why progressive taxation, for instance, provides a human rights compliant mechanism to increase revenue, redistribute wealth, reduce inequality, and sustainably fund education. And I will be explaining later on what I mean by progressive taxation. And during crises such as environmental disasters or armed conflicts, or as Megan was saying before, right, when we are talking about the cost of living crisis. But this is slightly different because some governments can be using this as an excuse, right, to talk about the state's capacity to fulfill its educational obligation, that when they can be strained. But this, in these cases, when there is any retrogression in providing free quality public education, this must be justified and demonstrate, and the burden of the demonstration falls on the government, right, on the state. And this demonstrably inadequacy of resources must be proved, and it cannot be a lack of political will to mobilize internal or external economic or non-economic resources. And even in these cases of genuine resource inadequacy, retrogressive measures must always remain temporary, proportionate, and closely monitored. And the guiding principles really explain this much better than I have seen anywhere else. And this is to ensure that the right to education remains always protected, even under challenging circumstances. So my paper is actually structured along 4 points. The first one is what international law principles say and the right to education say about the guiding principles, about the Abidjan Principles, right? So this is the legal commentary of the Abidjan Principles related to resources, governance, and financing of both public, but also private actors in education. The second one explains the concept of non-retrogression and the right to education, and this refers to the guiding principles 43 and 45 of the Abidjan Principles. The third part is the resource allocation for education and how the Abidjan Principles aid in the prioritization and strategic governance. And the fourth point is combating corruption and education finance, followed by a conclusion. So basically, what's important to understand is that this state's obligation, right, to protect, respect, and fulfill, they really remain in the Article 2.1 of the International Covenant on Economic, Social, and Cultural Rights. And when we are talking about the progressive realization, is to ensure the free and good quality public education, which Jackie has very well explained. I'm not going to go over it. But it's just to ensure the immediate, so the core obligation, and the ones that are more progressively realized. And this has to do with this flexibility of the different states. It's very important to be talking about the maximum available resources and the extraterritorial obligations of the state that go beyond their borders. And this is particularly crucial when we are talking about tax abuse, because this really robs governments from their capacity to finance education, to fulfill their obligations. And we are talking that at global level, tax abuse is $492 billion per year. This is the Tax Justice Network estimate. This is 347 billion comes from multinational corporations, so corporate abuse, and 144 billion come from wealthy individuals putting their assets in offshore. This is not being taxed. So in some of the iterations of the paper, I describe the difference between tax abuse, between tax evasion, which is legally wrong, and tax avoidance, which is morally wrong. Now, there is a really blurry line. So that's why we talk about tax abuse. And most of this, like whenever we have been talking to the international human rights bodies, they normally look more at domestic level. So for instance, what they are giving away in terms of tax incentives. I know that I have 2 minutes left, Hashira, no need to interrupt. So what we are having is just like, we really need to combat this, because giving away tax incentives and not tackling tax abuse, this is actually not being able to mobilize these maximum available resources. When we are talking about extraterritorial obligations of the states, is when these states or their companies are enabling, right? Particularly like when we are talking about tax havens, and remember that these are not only paradise islands in the Caribbean, but they are very much the UK and their crown dependencies. It's Switzerland, it's Germany, it's the US with Delaware and so many. They are actually, again, enabling these structures that robs other governments from precious resources, from the revenue that they could be collected through taxation. Again, it's very important to be using progressive taxation, so those who pay, who have more wealth or income pay more as a proportion. Another issue has to do also with debt repayment services. 3.3 billion people live in countries that spend more on debt repayment services than they spend on education and health. So this really needs to change, and the Abidjan Principles provide a great way of guiding how these resources must be spent. And also, when there are public-private partnerships, they cannot be the reallocation of public funds can never impair, right, these core obligations. So they can never impair the access to public good quality education, right? So this is something that I would really invite you to look at the paper, and I really look forward to your questions another time now. Thank you very much, and I will be sharing the links on the chat. Thank you. Over to you, Ashina.
Amazing. Thank you so much, Maria, for walking us through those critical obligations, right? Progressive realization and debunking that it's a stall, that it actually spurs on. There are some immediate obligations still embedded within the right, and how states can go about mobilizing more resources for education. So with the discussion on the obligation to provide public education and to finance it, there's still a key question that remains on what happens when private actors are involved, acknowledging that human rights law does not prohibit, for better and for worse, it does not prohibit private actor involvement in education. So what are the legal obligations of states in ensuring that private providers do not undermine human rights or replace robust public education systems? And to take us through that, I'll now welcome Dr. Roman Zinegrat, who is the Assistant Professor of Law at the American University of Paris, who will discuss the obligation to respect, protect, fulfill the right to education in the context of private involvement. Over to you, Roman.
Hi, everyone. Thank you, Ashina, and thank you, everyone, for organizing this. I want to say it's a great reunion for people I've now known for quite some years, who accompanied and walked with us throughout this project, from writing the guiding principles to then disseminating them and discussing them. And thank you to Megan for giving us the platform to publish the commentary. It was a pleasure to be part of it. To give you a framework of where I'm coming from, I'm professor of comparative constitutional law, and one of my major interests in my research is the relationship between the state and parents in the field of education. This is how I was asked to take part in the drafting committee of the principles. And I want to start maybe with contextualization of what we wrote for today, and then I'm going to go through the principles that I was asked to comment on. I think that when we were beginning to write the the first draft of the principles, our concern and the general concern in international human rights law in the field of education was the commercialization of education and the taking over its compatibility with neoliberal forces. Private education, the draining of resources, as was presented at the beginning beautifully of this webinar today. And I think in this sense, Jackie's excellent and very original take on the right to public education is very important still today. And yet the parental rights aspect of it, that is private actors and the ones that guide them, that is parents, were always the concern for international human rights. It was, say, if you will, an illegitimate child of international human rights law, because they were the concern of withdrawing into religion, withdrawing into communal value, and taking children and maybe money out of the public education system. But today, increasingly, it's now maybe not only neoliberalism we are worried about, but fascist and far-right forces that are now threatening not only to take some children out and exempt them from public education and maybe rechannel the resources, but increasingly threatening to take over the public education system through maybe the institution of parental rights. And so maybe we can discuss it during the Q&A if you'd be interested, but just to plug my research into this, I have two ways out of how we can rethink parental rights, maybe in the same way Jackie has rethought the right to education as the right to public education. I think that parental rights should not be considered as this exception to the regime of international human rights law and the child's right to education. It could be rethought either as part of the regulatory system, where parents are part of the separation of powers within a state and get their prerogative to control education from the state, or actually to be revindicated by the liberal forces and think about parental rights as a source of liberal and equality-driven education in international human rights law. With this being said, I'll walk you through the two principles. The principles are quite straightforward. The first talks about the scope and nature of parental rights, and the second is a limitation clause for those of you coming from the field of international law, speaking about the power of the state to limit these rights. So international human rights law walks the fine line between the reinforcement of the positive elements of private education and of parental control on the one hand, and the need to limit its potentially negative implications on the other. This delicate balance is chartered in Guiding Principles 47 and 48. General Principle 47 addresses two sets of educational rights. One concerns the rights of parents and legal guardians to control the education of their children. The other, the corresponding rights of private actors to establish and direct private educational institutions that offer alternatives to public education. In its last part, Guiding Principle 47 clarifies the limits on the scope of these rights, adding that private educational institutions must conform with states' educational standards. The requirement to guarantee the educational rights of parents has furthermore been read to include some positive elements, but these do not include providing financial, as been said, or other material support or active assistance to parents if they choose to pursue private educational options, save for limited exceptions. States, therefore, may choose to fund private educational institutions, but are not required to do so under international law, and the right to choose a private educational institution as well as to establish and operate them do not amount to a claim to establish or subsidize non-state schools. This general rule that states are not obligated to secure funding does, however, suffer two notable exceptions. First, several international instruments and bodies suggest that members of protected minority groups, especially those belonging to indigenous communities, are entitled to receive public funds for the operation of private schools if their needs are not or cannot be realized within the framework of state education. And the second exception stems from the principle of non-discrimination. While generally not obligated to fund private education, if a state does choose to do so, it must not discriminate in financial assistance between private educational institutions. Finally, the parental right to choose an alternative educational institution for their child does not seem to extend to home education, homeschooling, but international law does not prohibit the practice of home education, which means that states are free to authorize it even if it is not included in the scope of the parental right, as long as they ensure it conforms with minimum educational standards. States also have the authority to regulate private education. As I mentioned, the regulatory measures undertaken by states include the imposition on private educational institutions of minimum standards that may concern the admission, curricular recognition, or certificates, and other procedural or substantive elements of their management. Guiding Principle 47 recognizes the general regulatory power of states to introduce such standards, which is part mandatory and part discretionary. Having said that, the power of states to impose educational standards on private educational institutions is restricted by international human rights law. Among these restrictions are the principles of proportionality and non-discrimination, and the prohibition to equalize the regulation of public and private education. A comprehensive framework outlining the limits of state authority in respect of private education is developed in General Principle 48, set to guarantee the interrelated aims. That states protect the rights of children to education against their parents and do not violate the parents' right in education by pursuing state interests. Guiding Principle 48 is basically a limitation clause specifying the circumstances under which it is justifiable to limit the rights of parents and the operators of private educational institutions. The imposition of educational standards on private institutions inherently limits the rights set in Guiding Principle 47, previous one, and yet is necessary to establish the right balance between them and between the right to education, other human rights, and legitimate educational interests of the state. To guarantee this balance, the power of states to impose educational standards on and regulate private education is itself limited in scope. Private educational institutions provide parents and children with vital alternatives to public education. When the state fails to satisfy their educational vision and needs, they may serve as powerful engines of cultural diversity, plurality of opinions, and experimentation with new approaches to education, and serve as the main warrants of democratic values and human rights in authoritarian regimes as well, because human rights law applies to these too. But some private institutions are also notorious for increasing socioeconomic inequality, marginalizing disadvantaged groups, and compromising the capacity of the public education system to guarantee free, quality education for all. Similarly, the parental rights to ensure that the religious and moral education of their child conforms with their convictions may serve as an effective protection against state suppression of minorities' culture and traditions, but at the same time suppress the child's own wishes and preferences. Guiding Principle 48 sets these limits mostly based on the proportionality principle. As I have 2 minutes left, I will be moving to the last part of the talk. The Abidjan Principles take a decisively critical approach towards the commercialization of education and assign primary responsibility to realize the children's rights to receive education for the public education system. Yet, the principles also recognize the important role of private education in sustaining cultural diversity, in enabling minority groups and individual parents to pass their beliefs and lifestyle on to the next generations, and in restraining the state from abusing its overwhelming educational prerogatives. The ensuing educational framework pushes states to prioritize public education over private alternatives while preserving parental discretion in some educational choices. To ensure that children's right to education is protected regardless of other interests, the Abidjan Principles require states to guarantee that public and private educational institutions under their jurisdiction comply with the minimum educational standards. The international law framework set by the Abidjan Principles goes a long way towards the realization of educational rights in the face of neoliberal commodification of essential public services. Privatization is perhaps the most recent, but by far not the only challenge involved in the guarantee of universal free access to good education. Human rights law must not overlook other aspects of private schooling and parental prerogatives that hinder the children's rights to receive education. I've already hinted on these problems elsewhere, but the lack of a general state obligation to fund certain core curriculum aspects of private education risks depriving children sent to a private school by their parents from minimum quality education. Another more general issue that is not fully addressed in the Abidjan Principle is the need to develop substantive minimum educational standards that apply to all types of education, public and private, and this goes back to the question of other forces now using the parental rights for new purposes that are maybe perhaps even more dangerous than the neoliberal takeover. Further interpretive efforts of international human rights law must complement the principle's vital contribution to the guarantee of the right to education with a detailed list of substantive educational standards. Thank you.
Thank you so much for that, Roman, and indeed for situating us in the current threats that we're facing, the current challenges that we're facing, and how the Abidjan Principles were already equipped and are already equipped thanks to your hard work and the hard work of the entire team that worked on the principles and the commentaries to really make them comprehensive and anticipatory. So thank you. to all of the speakers for these very insightful, very timely, very nicely nostalgia-inducing presentations. And we will now turn to our Q&A session, which will be led by my co-facilitator, Aya. As a reminder, please submit your questions in the Q&A box. Thank you for all who already have, and you're most welcome to add to the questions. We'll address as many as is possible within the time that we have, and we look forward to hearing your thoughts and reflections. Over to you, Aya.
Thank you so much, Ashina. So quickly, that's a question from Samuel Safa. For any of the panelists to answer, in consideration of the limited resources, including competing budgetary demands, how could low-income countries fund free education for children? I see Maria is typing a response, so perhaps she can provide it orally. Thanks.
Thank you very much, Aya. Yeah, I thought that would be quite relevant for my paper. So yes, definitely. So there is always this, as I said before, there are differences in terms of the resources that different countries can have. Now, you also need to study how much they are actually allocating to, for instance, debt repayment services in low-income countries that normally eats a lot of the national budget, how much they are allocating to defense, how much they are allocating to other priorities as well. And what we are seeing more and more, and you will be hearing from the presentation, is also how much are they allocating to public-private partnerships, as Roman was saying. Like, they are using it, and we are seeing it in education, but also in other sectors, as de-risking, right? So they give some money to attract the private sector because this actually comes out of the revenue that they actually have to of the accounts, right? So whenever they are spending on public education, they need to justify it. And for instance, the IMF puts a lot of pressure to keep the inflation low, right? And then whenever they're spending more on education, they're spending more on health, they really say that they need to have this fiscal consolidation, which is another word for austerity. So that's something that we really need to fight back. And another way as well is to question the amount of tax incentives that they are giving, the harmful tax incentives, which is really not really bringing a good, like, private investment at all, but they are actually encouraging footloose companies that they only want to come and benefit from those incentives. So together with that, normally you have more than plenty, right, to adequately fund education and other public services and other rights. And again, please remember that this is not a competition. Education should not be competing with health. We should really be making the pie bigger. And this is something that David Archadai has seen as one of the participants is normally sharing in the presentations. So there are always ways to make this spending bigger. I will leave it for other panelists in case they want to chip in as well. And there was a second question I would like to answer further along. Thank you, Aya.
Thank you very much, Maria. So I'll move to the second question from Roslyn Onyango to Jacqueline. Thank you so much for your presentation. In addition to finding the relevance of public education in international law, what do the principles add in relation to claims for free education? Hasn't the law always provided for this? And finally, how can we advocate for the recognition of the Abidjan Principles in national law policies, especially as some countries recognize them just as soft law? Over to you, Jackie.
Thank you so much for those questions. On the first one about free education, absolutely. The International Covenant on Economic, Social and Cultural Rights has always talked about free education, particularly in relation to primary education. That's an absolute requirement that's set out in Article 13 and Article 14, so it's always been foregrounded. What I think the principles add here is two things. First of all, they're more explicit about obligations in relation to free education at other levels, so early childhood education, secondary and tertiary, and that is there in the International Covenant on Economic, Social and Cultural Rights, but the principles are helpful in bringing that all within one framework and referring generally to a right to free education rather than just carving off, which is what has happened a bit with the law, is primary education has just been carved out there, and the question has been, well, what about everything else? So the principles, I think, encourage us to look at that holistically and pick up on a lot of commentary and soft law around that. The second thing that I think the principles do really well is focus not just on the direct cost of education, school fees, but also on all the indirect costs. So the principles specifically refer to indirect costs of education. And here it's picking up all the commentary of the treaty bodies on expensive school uniforms, on sort of voluntary fees for books and teachers, which are not really voluntary, and all those indirect costs that are imposed that are massive disincentives to education and poses massive burdens on families. So I think they're the two ways in which the principles build on that bare statement in the existing law. As to the question of how do we advocate for it to be recognised in national law, this is such a good question, and maybe the question in some ways for us all taking the principles forward. And this is something I think about a lot. I live in Australia, and in Australia, about a third of children are in private schools, and the government funds private schools. And that's led to a huge disparity, with some private schools being incredibly wealthy and having a lot of money and also taking government funding, and some public schools being quite impoverished, and it's quite difficult. And so interestingly, the discourse around why we should have private education is that it's all about choice. But at the same time, we have all this private education. We have very intensive state regulation of curriculum and curricula and how we teach and how we assess. So in some ways, there's this sort of economic choice, but there's not really free choice in terms of what's happening in education. But to come back to the question, I think it's tricky because there is always going to be a strong lobby against moves to entrench some of these principles. They are controversial, certainly in Australia, but elsewhere, because private providers have so much invested in that, and some people have seen some of the paid legal advice that has come out arguing against these principles. I think our strongest tool, though, is to come back to the law. Like, these principles really are grounded in the law, and that's what the commentary shows. This is not us going off on a frolic of our own or progressively developing the law. Really, it's grounded in the legal principle. I think the other great tool that we have is repeating it and showing all these great examples of where the principles have been applied and public education. But there would be better ideas as well.
Thank you so much, Jacqueline. Thank you so much, Jacqueline, for these insightful answers. I'll now move to Roman. You have a question. How do you see parents' choice in picking schools and on the right to education impacting privatization, especially in countries where the states are not investing on public education?
Yeah,
you have 2 minutes.
Thank you. It's in a nutshell, this is the most difficult dilemma in the balance between private and public education in international human rights law. Human rights law has to cover for global north rich countries with an established system of public education, global south countries where the state is in no way near establishing a sustainable public education infrastructure, and non-democratic states in which private education is an outlet for minority groups to maintain a cultural, religious, linguistic, tenable system. So I would say in a nutshell, maybe one comment. It's a very difficult question. I think that much of the criticism of international human rights law from the global south that exists in the questions of human rights and development, telling global south countries, for example, you're not economically developed, but you now need to guarantee environmental rights. You now need to guarantee certain rights without you industrializing, for example, falls very neatly into the same issues of education. The global north telling global south countries you must invest in public education, and until then private education should be discouraged, is a big problem for not only for minority groups, for the majority in many of the countries in the global south. So I think that one way to think about it, in a very elegant way in which Jackie suggests in her article on public education does not have to mean only public schools. It could mean strict supervision with financing of other institutions that could accommodate private education while public infrastructure is being encouraged. I think this is the way out. And we need to remember that in international human rights law, when there is no infrastructure is one problem, and when there is no democratic infrastructure is another. Dealing with this is what the guiding principles, I think, were trying to balance, and that's how we moved to allowing and not suppressing and seeing and paving this way in international human rights law, of saying we're not suppressing private education. We are very concerned about supervising it. We're very concerned about the funding leaving the public education system, while remembering, and that's, I think, where the Abidjan Principles started this important work that must be continued, of developing substantive standards for what good education means in whatever system, which would allow the global south to get closer, ultimately, in the public infrastructure to the global north. Thank you.
Thank you so much, Roman. And in the interest of time, I will have to hand over the baton to Ashina to wrap up. But we really hope to address the unaddressed question separately. Ashina?
Yes, thank you, Aya, and thank you all for your very robust questions and for the very critical answers that have come through from the panelists. For the questions that are pending, like Aya has said, perhaps we can follow up on the answers. I know there's one on the UN Tax Convention on how this could apply to support states in the mobilization of more resources. Ooh, I'll hazard a little bit of framing or context on this, which is just one of the main challenges that even states that have the best intentions and would like to really allocate more resources to education sometimes face external constraints. And one of the key constraints has been the global tax system and how there are ways that it has been wired or fixed against states, right? So there have been massive loopholes intentionally placed that would favor global north countries or corporations and high net worth individuals to shift their profits around and avoid and abuse the taxation system to the detriment and disadvantage of low-income countries. So what the UN Tax Convention process is seeking to do is bring all parties to the table so that also low-income countries have a voice and a say in the international tax governance system, international tax rules and laws, and how those are enforced to ensure that they can contribute to sealing some of those loopholes that have enabled such a high leakage, illicit financial flows, theft, really, from these countries. Thank you so much to all of you for your participation in this conversation. I think as a parting shot is just to return us to the concept of justice in its multiple forms and the multiple things that are needed for that. This year, the African Union has declared it the year for justice through reparations. And reparations are a complex thing, right? It does include payment of compensation, but it also includes reformulating the structures and systems that have perpetuated the injustice and stopping any ongoing injustice. And we know that the failure of all children to be able to enjoy their right to education is an ongoing injustice. So as we think about that, what do we still need to do to the system? How do we still need to shift and change the system around to ensure that all children are able to enjoy their right to education? And human rights law gives us a very important and useful tool for that. And how can we use it alongside and in collaboration with other tools that are at our disposal, alongside other actors, other advocates, other activists who are also working towards this? so that we actually make concrete progress towards that change. So with that, I've been reminded to ask all of the panelists to please switch on their cameras for one group photo, I believe. Aya, maybe you can give more information on that.
Yes, please. Thank you all so much for attending and participating in this webinar. We really appreciate your insightful contributions. So for the end of the party, we would like to take a group photo. So if all panelists could kindly switch on their camera, and my colleague Juana will capture the moment. So Juana, let us know if we are giving our best.
Yeah. Thank you so much.
Okay. Good. Are we still smiling?
Everything is perfect. Screenshot taken. Thank you so much for everyone for attending. Thank you very much
everyone.
to the panelists.
Thank you very much.
Thank you, everyone.
See you all.
Good to
Thank
see you
you.
again.
Bye.
Bye-bye.